SJC-11583, Commonwealth v. John K. Rollins.
Ms. McGillian, you may proceed.
Good morning. May it please the court, Ines McGillian here for John Rollins. This case is on direct appellate review from 6 counts for possessing child pornography. Mr. Rollins asks this court to rule that 29C permits only a single conviction and punishment. No less important to Mr. Rollins are his claims that his convictions should be vacated for duplicity in count 6 and a First Amendment violation in count 6, insufficiency of counts 1, 2, and 3, and a series of extremely prejudicial trial errors that deprived him of a fair trial and ineffective assistance of counsel.
Counsel, if you would just focus on your first point for a second. Possession of a firearm is illegal. If I'm arrested with 3 firearms, there's 3 counts, 3 different firearms. Why is this different?
Why is this
different? 3 counts, 3 firearms. You've got possession of a photograph, of a pornographic photograph is a crime. You've got 3. Why isn't that 3 counts?
Well, I assume you're speaking about a Massachusetts statute that criminalizes possession of firearms?
Correct.
I haven't seen the statute, but presumably the statute clearly identifies the firearm as being the unit of prosecution. Without seeing the statute, it's hard to answer your question.
Okay.
There might be a similar or analogous issue if we're talking about how many bullets constitute having possession illegally of ammunition. If you have a big box full of bullets with 200 bullets in them, is that 200 units of prosecution?
Yeah. Again, it depends on the precise language in the statute and legislative intent.
So on that score, the thrust of your argument, I take it, is the second paragraph, if it is a second paragraph, but the part about first offense, second offense, and at the very least, it's ambiguous whether it refers to the unit of prosecution is the offense, as here, or each of the photographs, and the rule of lenity would say you need to go with the offense.
Yes, the penalty provisions in this statute provide some clarity. In light of the Commonwealth's practice, I believe Mr. Rollins has to concede that this statute is ambiguous. There's a long-standing practice by the Commonwealth of charging according to type of format on which images appear, or per image, or grouping counts according to format, or...
All of that would be discretionary.
All of that would be very discretionary.
But that's prosecutorial discretion, how many counts one brings.
The scope of the prosecutorial discretion claimed here is astronomical. And it is so astronomical that it brings us into a realm of vagueness. Unlike the statutes, unlike the cases cited by the Commonwealth on page 22 of their brief, which permit some prosecutorial discretion in opting between the actus reus or a per victim unit of prosecution, and these are all statutes criminalizing crimes of violence. Here, the Commonwealth has an option that is limitless and standardless and results in tremendous sentencing disparity.
Yeah.
So
Does
if the statute...
were the photographs all in one room? Were they are all in one location?
Here, we have a simple case where the photographs were all in the unallocated space of Mr. Rollins' hard drive. This is a unique situation. The unallocated space of this hard drive is a bit like an unmarked mass grave. So it is one locus.
Yeah.
There is no metadata that tells us anything about the spatial or temporal relationship between any of these images.
Does that make a
but
difference?
They were all in one place.
What if he had 2 different or 3 different computers with pornography on them? Would that make a difference?
I don't think it would, because we need to ask ourselves, does a man who has 100 photographs, 50 of them in a computer, 50 of them in a box under his bed, more or less culpable than a man who simply has 100 photographs under his bed? If the gravamen of the crime of possession is creating a demand for pornography and a market for pornography, and 2 defendants own the same number of images, does locus have any connection to culpability? I don't
Let us
think
say,
so.
for example, on the temporal side, let us say that one is able to deduce from the computer files which dates, the dates on which each image was retained.
Yes.
Could the Commonwealth charge possession on each of those dates for a different photo?
That is a very good question, and I don't know the answer. And thankfully, it's not the case here. I think you ask a difficult question that can be resolved on another day. But the temporal question is more difficult than the locus question.
If I could turn you to the issue of the jury instruction, did the judge provide any guidance to the jury as to what it meant to be lewd?
Very little instruction. It just said that lewd was either inoffensive or indecent. The danger with the
Offensive.
offensive
Offensive,
or indecent, sorry. The danger with the paucity of this instruction is that many people may consider mere nudity of a child indecent or offensive. And without an instruction that provides some more concrete guidance, some objective factors that a jury could consider, it's not just a danger, it amounts to a miscarriage of justice to
Are
fail to
there-
instruct on DOS.
I don't know this, and I didn't see. Are there model district court jury instructions on this?
Yes.
And is that the definition that those model instructions give?
I urge you to look at Model Instruction 7.540. It's cited in my brief and it's available online. It was recently updated in January 2013, and I believe it's entitled to some deference. It was drafted by a group of judges.
How does it define lewd?
Well, it actually requires
Oh,
instruction
is it
on
the DOST factors? Does it include those?
Yes, it includes the DOS factors. And it also includes an instruction that mere nudity is insufficient to convict a defendant. So I would submit that without an instruction, particularly in this case, where the images showed mere nudity and no sexual conduct, it was prejudicial error that could not be harmless to fail to instruct this jury that mere nudity was insufficient. It was also error to fail to instruct on the DOS factors, regardless of whether counsel failed to request this instruction. Their absence raises a substantial likelihood that my client was convicted for possessing mere nudity, and a review of the images confirms this.
Let me just return to the question of the numbers again. Does it make any difference if there were different subjects, different people depicted in the
Do you mean
different
the-
children?
The different, meaning the number of subjects in the image or the type of conduct that was being depicted?
Different children. So in
Different
other words, you
children.
have 6 photos with 6 different children. Are they 6 victims? Is that a victim analysis or?
If you think about the gravamen of the crime of possession as being creating a market for an image, and that image moves through commerce with those victims attached to that image, I would say that it's a difficult question that you're asking, but I would say that it should be image tied because the defendant owns a photograph that can be distributed to somebody else, and the market is defined by the item that can move in commerce.
Yeah,
The
but
fact
didn't the legislature want to protect children?
Yes, they want to protect children by shrinking the market for these images. A child is not directly and proximately physically harmed by a possessor's possession of a piece of child pornography. If a child doesn't know anything at all about their images being possessed by people out there on the internet, the harm to that victim is a privacy harm. If the victim knows that their images are being circulated, there can be an emotional harm or a psychological harm, but there's no repetition of the abuse. And without a defendant who proximately and directly causes physical harm to a child, it would be inappropriate to assign criminal liability for the harm to that child as a victim of a violent crime.
But the legislature has chosen the word child in the statute, what does that mean? If it doesn't mean every time you have a photo, you victimize that child.
You're speaking of a very interesting sentence in the legislative findings, where the legislature says each time an image is viewed, a child is harmed. And when I read that, I asked myself, is this a rhetorical question? Is it a factual finding of a verifiable fact? I think at most what that sentence can say is that there's a societal harm. Each time an image is viewed, there's most certainly a privacy interest that is violated when an image is viewed. But it does not necessarily mean that a child is actually physically, emotionally, or psychologically harmed at
Well,
each
if a
viewing.
child is posed in a certain way to produce a pornographic image, that child is a victim, right?
Yes, that child has been victimized by the producer of the child pornography. The suffering that the child experiences later when that image is circulated and the child knows, an identified victim knows about its circulation, the subsequent harm to the child is psychological and emotional.
Okay,
It's not-
but what about, to use an example that's totally non-equivalent, but the receiving a stolen motor vehicle statute? It's not the person who stole the vehicle who's being punished. As in your example, it's not the person who produced the image necessarily. But the legislature decides that the fact of possessing this object that has been stolen by another person, why is that different in this case?
Well, if I can put a twist on your hypothetical that might help me understand it more. Let's say this car was stolen from two people. So two people have been victimized by its theft. And the ultimate purchaser of this car or receiver of this car, is that person liable for the injury to the two people who lost possession of their car, or are they liable for receiving a stolen car? Without physical harm and injury, criminal law usually permits a per-victim unit of prosecution for crimes of violence, not crimes that pose some risk, not crimes that cause emotional harm.
But if the legislature is trying to shrink the market, as you said, it doesn't accomplish that purpose by treating photographs, pornographic photographs of 6 different children as if it was just one unit of prosecution. And it furthers that legislative goal by treating it as 6, doesn't it?
Well, if I hear you correctly, Justice Spina, you're concerned about a defendant being accountable for each image that he possesses. And that is possible under my proposed reading of the statute because a judge is entitled to sentence either at the high end or at the low end of the sentencing range. And if a defendant with a large collection of 100 images wants to be liable for each of those 100 images, it would be inconceivable for the Commonwealth to charge them with 100 counts, individual counts of possession.
So you would say in answer to Justice Spina that in that case, if the judge was very concerned, the judge would, for example, impose a state prison sentence
Correct.
Rather than a House of Correction sentence.
Correct.
Would you agree that the Commonwealth could bring 6 different charges, but perhaps could only get 1 sentence?
Well,
Like the case
If
from the
the-
appeals court, which is what happened there?
if you're suggesting this as a middle ground, I don't see any evidence supporting that construction in either the statute or the legislative history.
But you agree that 1 photo is enough for a possession charge, right?
I agree that one, you could be put to prison or given a probationary sentence for the possession of a single image. It does not necessarily follow that each image is the unit of prosecution.
But in a case, I think you cite as being in your favor, the Commonwealth versus Beacon Distributors, Inc.? I understand it's a different
Yes.
section of the statute, 29B, I think, maybe? Anyway,
Yes.
but it was a case in which there was a whole bunch of counts, and then the court said, yes, Commonwealth, you can prosecute under all those counts, but at the time of if there's convictions, you got to go on one, right?
Yes, because a conviction has serious collateral consequences for a defendant.
I mean, isn't that what Justice Cordy's suggesting?
He's suggesting that perhaps there could be multiple counts, but only a single sentence.
Right.
Right.
I don't see any support for it in the statute, in the legislative history, and and it would violate the rule of lenity, that a statute should be construed strictly against the Commonwealth and in favor of a defendant. There's nothing in this statute putting a defendant on notice.
Why wouldn't it be cruel and unusual punishment to impose a sentence perhaps consecutively on each one of those? Why couldn't that problem be dealt with that way?
Because the standard for what constitutes cruel and unusual punishment is so high that it is not a sufficient limit on the Commonwealth's discretion to expose defendants to stacked sentences. What I see happening here is I see that my time is up, but if I could just conclude this point. What I see happening here is that we have a statute that has not been amended since 1997, and the problem of child pornography has blossomed into a bigger problem. And it is inappropriate for the Commonwealth or for courts to enlarge their hammer by interpreting the statute to permit multiple counts when the legislature's original intent was to permit one count of conviction and one sentence. And with that, I rest on my brief.
All right, thank you.
Thank you.
Good morning. May it please the court, Bethany Lynch, Assistant District Attorney representing the Commonwealth.
Ms. Lynch?
Yes.
So let's assume someone is arrested for possession of marijuana and they have 6 one-ounce bags. Would it be permissible for the Commonwealth to bring 6 charges, 1 for each bag?
I actually gave that some thought. And I would argue that that case would be different because in that case, the possession of a commodity, a substance, is what is being criminalized. In this case, the unit of prosecution is a victim-based versus more of a narcotics or a property or a crime such as that.
Victim-based? So if you have 6,000, however, 049
Yep.
photo on that CD, and they're all of one child, that's one victim?
I would argue no, because they would be separate acts of victimization of that child.
Okay, so then you said that you could have 6,049 counts times 5. That's the sentence for a first offense?
In theory, yes.
Well, what's to stop it?
That's where
What's to
prosecutorial
stop? Oh, so-
discretion comes into play.
Oh,
And
so that's the standard? Whatever the prosecutor, what the upper limits of prosecutorial discretion is how we're to interpret the statute?
No, you're to interpret the statute as it is written by the legislature, and the legislature made it very clear that the point of this statute is to protect the child, is to protect the victim of the photograph, or the image, or the negative, and it references it's a singular description within the statute. There's the preamble to the statute, which discusses all of these photographs or images being an invasion of a child's privacy, about the emotional injury to such child. That is what the legislature sought to prevent.
Now, well, let's assume for a second that what is found in the possession of the defendant is a book that has lots of images of child pornography. 1 count?
It would be 1 count because it would be 1 book as written.
What if it's
As the
the
statute is
defendant's
written.
own personal photo book, which he has assembled? So it's just a photo book, a book of images.
6,049
But
of them.
of images of children, nude children in lewd poses.
Correct. A photo book,
Then, but they're individual photos?
But in one book.
a book.
I would argue That's where the discretion would come in. Depending on if we could identify where those photographs came from, did he take all these photographs and so they were individual photographs that he then
Maybe
put
he
in
bought
a
a book,
photo album?
bought a book
I would
of
argue that,
bought a photo album.
then
Bought a
I would
book.
argue that those are individual images.
So if he has the book published,
If he has the book published, then it would be a book, per the statute.
I mean, the
Now, you
practical,
didn't actually use a victim-based approach here, because in some of the photos, there's more than one victim.
We used
Used
an
an image-based
image-based, the
approach.
image of a child or children. In that way, I recently reread the Constantino case, and that case deals with, it was a automobile crime. It was leaving the scene of an accident. And in that case, there were 2 victims harmed in the accident, but the statute reads, any person. And so I would analogize it here in there's one photograph, one image, and the image, if it contains more than one child, I would not argue that the Commonwealth will be entitled to indict or charge per child within the image.
why?
It's with,
They're both victims.
they are both victims, but the statute reads that it is per image, that a photographic image is the unit of prosecution.
Well, what if it was in the old days, the old 8mm moving picture, and there was 5 minutes worth of moving pictures and maybe 200 frames? Is it 200 units of prosecution or one?
Under this statute, I believe it
It would be a film.
It would
That's
be a
one.
film. Yeah, I didn't have all the examples written down, but I believe that would constitute a film,
Single unit.
a single unit, the film, or a book.
And if the film was developed in such a way that.
If you took a
that there were
still-
200 separate
Right.
images.
I would argue that if you took a still and printed it, then that would be a single image, and that could be a
Each
unit of
separate
prosecution.
still, even though you made a single
Yes.
purchase of a video.
Yes.
That was what you did.
That's what you
by
did with
putting
it,
that out
and
into
by
the.
possessing all of the different, yes, I'm sorry.
Well, that doesn't really address the increasing commerce in child pornography. Buy the video, and then you've got 200 images that you put in a book, or you don't put in a book, but you have them around.
I'm sorry, I didn't follow the beginning of
Break
that
down
question.
the video, you buy one video, you pay one price, so
Yes.
that's how you were out there in
Yeah,
engaging in commerce with respect to child pornography. And then at home, you've got equipment that allows you to break it down, so you don't have to see the video. It's more convenient to have them separately and look at them individually, and you've got 200 photos.
You do, but then you would be subject to prosecution for the 200 photos for taking one unit and making it more. You're expanding
What?
your possession. You're expanding the amount of child pornography that you possess by printing it into various specific select.
And the same with a
Things.
single image that you then copy, and you have 5 copies.
If it was the same image, I
Want to
would
be sure to have one in every room of your house. You've got 5 copies.
argue that if it was the exact same image, then no.
now, a maximum sentence for rape is 20 years?
I believe so. But if you raped 6 women, then your maximum wouldn't be 20 years. You would be subject to a maximum 20 on each of those rapes.
But
And that is what I would
Do we
argue.
understand that the legislature intended that if you possess more than 10 photographs, your maximum now is greater than for rape?
Do I know if the legislature understood that? I don't know.
That would be the consequence.
It would be a consequence. But I know that the legislature, by their own preamble, found that this was a very serious crime and that they were taking this step to minimize. And if there are 6 victims, theoretically, in any number of crimes, if you have multiple counts, you can get consecutive time. And that's what the legislature
Right,
provided for.
But the nature of child pornography is that it's almost never a single photograph.
Exactly. But that doesn't make...
Almost inevitably, then, we're going to have, in any case that would be worthy of prosecution, you're going to have a maximum sentence, which is going to be
30,000
extraordinary.
years in this case.
I'm going to trust you on the math on that. In theory, yes, that is how the statute is written. That is how, in theory, they could get up to that amount of
So
time.
do we understand, I mean,
But-
there's no doubt that the legislature was concerned about the market in child pornography. Do we understand that they thought that that market was more serious than the act of rape or than the act of indecent assault and battery? Because it ultimately is producing a maximum that would be greater
Well,
than
you're
those acts.
certainly impacting more children directly. I don't know that the legislature did that they compared various crimes and said, well, if they commit the same crime to innumerable victims, they could theoretically be subject to a much higher sentence.
Can I ask you a question about this, the penalty phase? When it says the first offense, you get, state or, and second offense. In other statutes that have an enhanced penalty for the second offense, I didn't go back and look, but my understanding is that the language is usually if the defendant has been convicted of a like offense.
Yes.
When this talks about first or second offense, how is one supposed to figure out in a case like this where you have 6,094 pictures, which is the first and which is the second? Or do we have to read in, it means at a different time, that usually is not implicit, it's usually explicit what it means.
I agree. Usually it is explicit. In this,
Any
I would
other
argue
statute
that
in which it's implicit?
I do not, and I did not look into that specific question. But I would argue that in charging, when the Commonwealth makes its decision to charge, we need to look at the state of the defendant's record for an enhanced at the time of the charge. So we couldn't have charged him as a second offender because prior to his conviction, he had never been charged. So you can't wait for, count one, he's guilty. Well, now count two is his second offense. We wouldn't-
Or sever them for trials.
But I believe that you have to charge them initially, charge in the charging document, you would have to put forth that you were proceeding as a second offense. And I don't believe that we would presume to charge as a second offender prior to receiving the first
Okay,
conviction.
but on your, well, anyway, it's okay. You had a
Yeah, my question was, again, on the penalty phase. I mean, there's an absurdity that's possible if you were to exercise prosecutorial discretion and charge with, say, 100 of these images, which, adding up would be beyond a natural life. And so you'd never get to the second or the third offense.
I would imagine theoretically that's possible, yes.
And it's all sort of tied in with just pure prosecutorial discretion. You think that's what the statute means?
I don't know that the statute means that it's all tied into prosecutorial discretion. I know that the statute means that an image is the unit of prosecution. Now, the statute could
Where
be
is that
better.
so clear in the statute?
Well,
I'm
it
not
says-
finding that language just as transparent as you seem to think it is.
The facts of the preamble that focuses on the right of the child, and then the facts, the language of the statute itself, where it references a negative slide,
So if it
photograph,
said
or visual
whoever
representation.
possesses negative slides, books,
That's
magazines, you would say.
plural.
That's
Yes,
plural,
I would
but-
argue
But
that's
A can be
plural.
singular or plural under statutory interpretation,
But a negative, a
or negatives.
slide. I think that the language, in light of what the legislature was trying to accomplish by the statute, the language is
If the
specific.
legislature said whoever knowingly possesses negative slides, books, magazines, would you say you couldn't prosecute unless you had more than one negative?
No,
Right.
no, because you would be within if you are possessing negatives, you have a negative.
Can I turn to the representative sample?
Certainly.
I took from your brief that whatever this representative sample was, some of them didn't show nudity. Is that
None
right?
of them showed nudity.
Well, then how can it be representative of this crime?
It's
Doesn't this crime
representative-
require nudity as a
It's-
starter?
Yes, and we didn't put in additional nude photographs, which would have been uncharged conduct. In this case, the representative sample was used to show the defendant's intent in possessing the photographs on his computer. They were all of a similar nature.
Is that in dispute?
It was. The defendant claimed that he did not possess them. He had given a statement where he said that he did, but then at trial, his main defense was that the Commonwealth could not prove possession.
But you're saying that's representative of a crime that requires nudity to have have 6 photographs or however many were in the sample that don't show nudity?
Yes, because the photographs showed other things. They showed they were a similar age girl. They were in similar, I would argue, sexual poses. They were absent the nudity. I would suggest, I would agree to that. But for that, they may have satisfied the statute in other ways. So the defendant was.
And this proved that what?
That he knowingly possessed the images on his computer and that he.
How does this add? How does this add to the evidence of knowledge? He had so many pictures. He has to have known he had pictures.
Some of them have to violate the statute?
Yeah, some must.
No, I mean, we set out which ones we averred violated the statute. He also possessed others. There was much evidence that there were other pictures on the computer
didn't violate the
that did not violate the statute, and there was testimony about that. So these
what?
pictures
I mean, what?
showed that he collected pictures of young girls in sexual poses.
Didn't we say in Rex that you
Certain-
need to look at just, it's not the context, it's the photographs themselves?
in terms of determining whether or not they're lewd, but in terms of the relevance, I would argue that this is relevant evidence of the defendant's possession of these photographs and intent to possess photographs of young girls in
But
sexual
that's not a
poses.
crime.
It's
You're
not a
making it
crime,
into a crime.
But it's relevant to his state of mind in committing the crime that we did charge.
But he acknowledged having
was-
downloaded all of these photographs.
He acknowledged that in a statement. He also denied it when speaking to the police early on. So it wasn't an outright admission. He gave a statement where he tried to downplay his role, saying, yes, I downloaded them I was going to give them all to the police. There was also evidence that he then deleted them all. There was also evidence that he denied any knowledge and said someone must have put them on my computer. So the main thrust of the defendant's closing argument was that the Commonwealth failed to prove that he possessed anything on that computer. So
Any limiting instruction that accompanied these 5 representative?
I do not believe that there was. But the defendant did not raise an objection to them. So there would have to have been a substantial risk that these photographs created a miscarriage of justice in this case.
That's not so hard to get to.
I would argue that it's not simple to get to in light of the evidence against the defendant and in light of the photographs that he was charged with possessing and and in light of his statement and the testimony offered at trial. The evidence was very strong. So I doubt that these photographs that were representative of other pictures on the computer were what swayed the jury to convict the defendant in this case.
Do you agree that as part of our job, we need to evaluate the sufficiency of the evidence by ourselves, looking at these photographs to determine whether or not they are legally sufficient to be viewed as lewd?
I do. I believe that's a de novo review, only on the issue of lewdness, whether they qualify as
And
lewd.
as part of that, we are to be guided by the DOST factors?
You can use the DOST factors as a guide, but they are not definitive and they are not mandated. The photographs don't have to satisfy all of them.
But
You know,
they
they're
are to
a
guide
guide.
us.
Yes, they are to guide, and I would point out that it's
And
my...
is there a problem that the guidance which we are to apply in reviewing these photographs was guidance not provided to the jury in this case?
I admit that they were not given to the jury. This jury instruction, I believe, was in 2013. This trial was in early 2013. I'm not sure about the overlap there. But I would argue that in terms of the jury instruction, the jury was to determine whether or not the photographs were, were lewd.
Indecent?
And
I will
that
inform
was
you
an
that the term
accurate...
lewd under our statutes and case law means, quote, indecent or offensive, close
Yes.
quote.
And that's an accurate statement of the law. And under cases, I believe it's the Sullivan case out of Massachusetts, they are not, the dose factors don't necessarily define what lewd is, and that a layperson looking at a photograph, knowing that they're looking for indecent and offensive as their benchmarks, a layperson can look at that and know whether or not that is, without applying specifically a series of factors. And there's also case law that I've cited in my brief that says that those factors can be confusing and overly generous to the defendant. All of these things are considerations for you in determining whether or not this jury instruction sufficiently informed the jury what they needed to look for.
All right, thank you.
Thank you very much.